it's irrelevant. It doesn't matter. It gets so confusing, though, in Supreme Court. Like, who's the appellee and appellant and blah, blah, blah.
Because it keeps going back and forth, right?
That's right. Lawyers just do that so they can drive Porsches, okay? So
this is Las Vegas Real Estate Now with local real estate expert Harvey Blankfeld.
You were telling me before the program that we have a new case that's taking place up in the Nevada Supreme Court here about the seller's real property disclosure, right?
Felino came out in March, and here's what happened. It was Mount Charleston house. They bought the house. Buyer moves in. Their insurance goes up as soon as they move in. Why? Because there had been a water invasion prior. Insurance companies will look back on a CLUE report and say, this house had a water invasion, therefore your insurance is going up. Buyer became upset, looks into it, says what happened, and the seller says, yeah, I had a water invasion, but I had it fixed through my insurance company. Buyer goes and looks and finds mold. Says, oh, you didn't disclose, and you didn't tell me about the repair. Sues, wins, gets a $250,000 judgment. Seller appeals it to Nevada Supreme Court. Mount Charleston case. Nevada Supreme Court said, wrong. That $250,000 judgment is in error. The seller didn't have to disclose something they fixed. The definition of a material defect is something that you're experiencing now. If you fix it with a licensed contractor or a proper person, blah, 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 it is no longer a defect. Wow. That was the case law. 8 months later, the Nevada, the real estate division modified the seller's real property disclosure form for the state of Nevada. Why? We don't know.
Yeah.
They added 2 sections. Basically, one was basically water and then things you're aware about. But here's the language they used. Has your home ever, EVER, have you ever experienced blah, blah, blah?
Right. Changes
everything. Goes back to the dawn of time. Last month, the Supreme Court came out and said, we have a new case called Felino. And that's what the case was. The buyer buys the home, finds mold, digs into the deal, says, we learn they had a mold problem 2 years ago.
Right.
Seller didn't disclose it. Sues everybody, goes to court, buyer wins, seller loses, goes to the Supreme Court. Supreme Court says, why are you guys not listening to us?
Yeah.
They said, we don't care what the SRPD says. The SRPD is not the law. The seller's real property disclosure form is not a law. The legislature in 1995 wrote 113, and it says, if you have a material defect, you have to disclose it.
Right.
We defined in the Charleston case what a material defect is.
It's as of right now.
Right now.
Right.
And if you don't have something broken and you had it repaired properly, you don't have to disclose it. The whole case gets thrown out.
You've been listening to Las Vegas Real Estate Now. If you ever have a question about real estate or any of the other topics we cover, just call me off air or text me at 702-203-1165. You can also check us out on the web at lvrealestateradio.com or on our handle on social media at LV Real Estate Radio.